Hi everyone, this brief lecture is meant to introduce you to some basic concepts in employment law. Please keep in mind that we do have a full course that goes much more in depth into each one of these ideas, but this content is really just meant to introduce you again to some of the basic ideas that are important to know about, and then note that within the D2L course shell, we also have some links to information that would allow you to go more in depth into understanding each of these concepts and the laws that we're going to talk about. So let's start with a basic principle, which is the idea of employment at will. And in most states across the country, we have this concept of employment at will. What it basically means is that an employer and an employee at any time, for really any reason, can decide that they no longer want to engage in this employment arrangement. In other words, I can decide one day when I wake up that I no longer want to work and quit my job. Or an employer can say, you're terminated. And so this employment at will arrangement basically says that you're not guaranteed employment. There are a few exceptions to this, public policy. So there are laws that might say, what are some reasons that are explicitly illegal for terminating an employee? There are some arrangements where an employer might have an implied contract with an employee. In other words, they have an oral agreement or in a written agreement that expressly says, for example, let's say you're working as a temp and it says we guarantee that for the next 2 weeks we'll provide you 40 hours of work. That might be the kind of arrangement where employment at will would no longer apply. And then we also have something called covenant of good faith and fair dealing in a few select states. But in general, most employers are operating under this employment at will concept, which says there's no legal guarantee that you need to continue providing employment. And this is not the case in all countries, right? So there are some places where employers are only allowed to terminate employees for just cause. There are some countries that go even further, that really look at this employment relationship as an obligation that the employer provides for the personal welfare of employees. And again, in that way, we kind of go much further than employment at will to say it's very important that you continue to provide an employment opportunity for your employees. So this is something to consider, kind of how you feel about this and how this impacts overall our approach in HR. But know that currently, right, that we are working under an employment at will situation for most of us. Which brings us kind of to the next topic, which is unions and collective bargaining. Obviously, when we're working in a union situation, what it means is that there is an explicit contract for employment. In other words, when people are working under a union contract, right, there are rules and guidelines, and it's a legal contract, just like if I was going to buy a house or get divorced, where all the terms of employment are kind of covered in the union contract. So we go back to 1935 when the National Labor Relations Act passed, and this law basically established the right of workers to collectively bargain, to be looked at as a collective bargaining unit, that on behalf of the whole group you can engage in bargaining and create employment contracts. This was really meant to protect the rights of employees and employers, and it also identifies what are called unfair labor practices. So the National Labor Relations Act would outline what is legal and what is illegal for both the employer and the collective bargaining unit to do as they go through this process of trying to come up with a union contract. And this really is the major exception to employment at will, is when people are working in a union environment under those contracts. So when we think about kind of what is a union, really it is people that have similar interests, similar working conditions, and the law looks at them as that collective unit that can bargain together. This fundamentally shifts the employment relationship, because when we see a union environment, again, really it will be the contract that's going to dictate what are the work rules, what are the benefits people are allowed, kind of how you can treat them and how you can make decisions. And every union contract can look different. In other words, what has been bargained for and what hasn't been bargained for. Some contracts might not address issues of time off. Other contracts might address every issue that we could think of making a decision around related to HR. So this is a very big area of law, and again, we could go much more in depth, but it's just important at this point they kind of understand what a union is. We're going to move into the next topic, which is sexual harassment. Hopefully you've taken a look at the EEOC website and learned a little bit more about this, but I'm just going to cover a few key points. So sexual harassment has over time generally been defined as discrimination that's based on gender. And the reason that sexual harassment is illegal is that it would be considered a violation under Title VII of the Civil Rights Act. And for that reason, we see this as a law that is enforced by the Equal Employment Opportunity Commission. In terms of defining what is sexual harassment, we think of it as unwelcome sexual advances, requests for sexual favors, and verbal or physical conduct of a sexual nature that occurs under the following conditions. So I want to take us to the next slide and just talk about kind of really what are the two forms of sexual harassment that come up. One is quid pro quo and one is hostile work environment. So this is really kind of the two primary categories or types of sexual harassment we might see on the job. Quid pro quo, another way to think about this is something for something. So a quid pro quo sexual harassment happens when, maybe we see a supervisor implying that in order to get a promotion or to get a raise, in return for that, you need to go on a date or perform some sort of sexual favor. We think about that as something for something or quid pro quo. So if you're working in an employment condition where you have to agree to some type of sexual activity in order to either not be punished or get some reward, that's where we think of this as quid pro quo sexual harassment. But sexual harassment can also occur just by being forced to work in what we would think of as a hostile environment. So here, if within the work environment you feel intimidated or it's hostile or you're offended by behavior, that can also be considered sexual harassment. So some very, I would say, this is if you need to come to work and people are making comments about your appearance or they're making inappropriate jokes or someone has a lewd calendar that's hanging in their office, or just kind of, again, that general, it can be verbal, physical, or visual conduct that really is offensive or intimidating or hostile. We think of that as hostile work environment. And both of those are considered sexual harassment. But in terms of the law and defining it, it is important to know the difference between quid pro quo and hostile environment. Another area of employment law that's important to be aware of is what we think of as wage and hour. And here the major law that impacts this is the Fair Labor Standards Act. So this is a federal law that impacts states across the entire country. And it has a really large impact, right? Because it tells us what minimum wage would be. And also it sets these guidelines that employers are required to pay overtime. When we think of this term that we call their role exempt, what we're really talking about with if someone is exempt, generally what that means is that they're exempt from the Fair Labor Standards Act. In other words, FLSA does not apply to them. And those would be positions where maybe someone is not required to be paid overtime. Kind of in a salaried role. But again, the Fair Labor Standards Act goes really in depth, right? This is a big law. And if an employer chooses to consider someone as being exempt from FLSA, it would be important that you look at the FSLA standards. There are, again, rules and regulations around this that would actually say what categories of work or employees are truly exempt from this law. Violations of the FLSA would be reported to the Department of Labor. And if you're in violation of the FLSA, it's within their rights to come out and examine all of your wage and hour and payroll records, and there are fines for violating this law. In other words, one interesting note is just this year, 2019, in Minnesota, we actually have heightened enforcement of what's called wage theft, so kind of violations around these kind of rules. And it brings us to the next idea that most states across the country have their own wage and hour laws. So it's important when you're working in multiple states to understand that the FLSA applies to everyone across the country, but then if you're working in Minnesota, for example, there's an additional law specific to Minnesota that might heighten these requirements, and not only within the state, but maybe within the local jurisdiction. So in Minnesota, we could adjust our minimum wage, or even in Minneapolis as a city, they might decide to pass a law that applies just to that city. So this is where, Minneapolis, effective July 1st, increased their minimum wage, which again is much higher than the FLSA standard, but really you're held to the strictest law that applies to you. So for companies that have multiple locations working across the country, it's important not only be tuned into the FLSA standard, but also kind of what are those local standards as well. And note that there are kind of, as I was saying, in Minnesota, now we have this wage theft enforcement where it's considered criminal to underpay your employees, and it's something you could go to jail for. So these are really significant laws to tune into. The next category is discrimination. So here we get into these discriminatory practices connected to law. The most sweeping or largest law that's important to be aware of is Title VII of the Civil Rights Act. So this is our major federal law that created the Equal Employment Opportunity Commission, which we often refer to as EEOC, to enforce these laws. And again, I'd encourage you to go more in depth on this in the EEOC website to better understand these. But the categories that Title VII protects people is against discrimination based on race, color, religion, gender, or national origin. Traditionally, when we looked at this law, this idea of gender discrimination was specific to what we think of as male, female, binary gender. It did not in any way connect to sexual orientation. We saw some interpretation where this law was being interpreted to protect sexual orientation, but more recently under the Trump administration, this is up and there's a question, and so we're waiting for a Supreme Court ruling to really clarify this a little bit further, but what we know for certain is that Title VII protects gender discrimination in terms of male-female discrimination. We also have the Equal Pay Act, and here we say that if a man and a woman are doing equal jobs, they must be paid equal wages, and that dates back to 1963. The Pregnancy Discrimination Act basically says that you need to treat pregnancy as you would any other disability, so allowing for special treatment or what we think of as accommodation when someone is pregnant. You can't fire someone because they're pregnant. The Age Discrimination Employment Act protects folks based on their age. So federally, we're looking at this law that applies and says if you're 40 or older, people have protection. In Minnesota, we have a law that says if you're 18 or older. So here we need to be very careful to say, as we're hiring people, are we using age as a criteria, a qualification, giving preference to age? Again, because that would be considered illegal potentially. The Civil Rights Act of 1991, this was really kind of elevating some of the civil rights acts that had been, or laws that had been passed earlier. But here in the early 90s, we start to say not only are these things illegal, but they're actually going to be compensatory punitive damages. In other words, employers are going to have to pay fines and money if they're found violating these things. And compensatory damages can be awarded to employees. So if employees are subject to discrimination, that courts can award them money. So it gave some teeth to these laws that we had seen earlier passed, and that again was not until 1991. Around the same time, we also got the Americans with Disabilities Act. So again, this is the federal law that protects people from discrimination based on disability. This law protects people that are qualified for the role with or without accommodation. So you have to be able to perform the job, but you can do it with some accommodation. And when we think about a disability, this is really something that inhibits a major life function. So if I get a cold and I'm really sick for a few days, that does not mean I'm disabled, obviously. Again, the ADA, the Act itself goes into much more depth in terms of understanding this, but just generally we think of a disability as something that would inhibit like breathing, walking, thinking. There are a lot of mental health conditions that are considered disability. In fact, one of the most debilitating disabilities across the country is depression. So when something like depression inhibits a major life function, where you are having trouble, like for example, getting out of bed, you could seek protection under ADA in terms of your employment situation. The law would protect you there. Another key concept that I want to bring up is this idea of adverse impact. So in 1971, we had a really impactful case, which was Griggs versus Duke Power, that the Supreme Court looked at. And what this case identified is this idea of what we think of as disparate impact. In other words, disparate treatment is kind of, I would define it as intentional discrimination. So if I'm going through the hiring process and I decide, I don't want to hire someone because they are of Asian descent, and my only reason for not hiring them is because I, consider them to be Asian, that's disparate treatment. In other words, it's intentional discrimination. But in Griggs versus Duke Power, what we saw is you might have a policy. What Duke Power was doing is they had a testing process that disproportionately excluded Black people from the hiring process. In other words, the tests and their hiring process impacted to a much greater extent Black people than other people. So these kind of processes or approaches, even if they're not intentionally discriminatory, where you set out and say, I'm going to have this policy or practice because I don't want to hire whatever the group might be, disparate impact is still illegal. So this was, again, very impactful, because what it tells us is if you have processes or policies or approaches in place, that whether or not you have this intent to discriminate, if the impact is that it is disproportionately excluding certain people, whether it be based on their race, their color, their religion, the sex, or the national origin, that would be considered disparate impact, and that's illegal. The last category we're going to look at really briefly is employment law related to safety and health. So some key laws here are what's often referred to as OSHA, or the Occupational Safety and Health Act. And this kind of regulates safety in employment situations. So this is where, if you have hazardous substances or unsafe working conditions, it's important to know about OSHA regs. There's a lot of reporting and monitoring, again, that the federal government is allowed to do based on this law. The Family Medical Leave Act, FMLA, requires organizations to allow employees to take leave. This is unpaid leave. So if you choose to pay someone while they're off on this leave, that's discretionary. But what the law requires is that you just give them time away and protect their job. And what they're allowed is up to 12 weeks. And this could be if you have a new baby, if you're seriously ill, if your spouse, child, or parent is seriously ill. Let's say my mom is seeking cancer treatment and I need to bring her to chemo. This is where if I qualify under FMLA, I could take up to 12 weeks of leave to do that. Again, unpaid, to be able to care for her. And then the last one is the Immigration Reform and Control Act. And again, this is an important law just to tune into because this is where we get our guidelines for kind of who is allowed to work in our country and what kind of proof of identity they're required to provide employers. So hopefully this has been a brief introduction to the topic of employment law, and make sure you tune into some of those more in-depth tools that I've given you this week to take a look at.